Uh, Thanks, Tove. And I'd just like to thank Tove and Lavenda for the opportunity to contribute to the book and to the organisers for the opportunity to participate in the conference. In the book chapter and also in the presentation, I address one potential dimension to autonomy arrangements that's often overlooked. And that's when the state grants autonomy to a community to regulate certain matters in accordance with their own religious or customary laws, that this generates a form of legal pluralism. I think this needs to be made explicit, given the implications to which it can give rise, which go beyond those normally associated with autonomy arrangements, whether you're talking about territorial or non-territorial autonomy arrangements. Now, the focus throughout in my chapter and in the presentation today is on legal rather than normative pluralism. And that's not just because of the considerable symbolism that attaches to how a community's value system is classified and whether the community's own perception of that system is a legal rather than normative one is accepted. I think more importantly, there are distinct implications that attach to legal as opposed to normative pluralism, both for the community in question and for the state. And not all of these implications might have been intended or even foreseen. And this stems from the fact that some, but by no means all, of a community's religious or customary laws will quite often reflect traditional views of gender relations, for example, or community punishments. And so they can often sit uneasily with contemporary human rights standards. That's not to elevate these global human rights standards to some form of new 21st century divine law. It's just simply to recognize that all states have accepted some international legal obligations. All states have accepted at least one UN human rights treaty, and compliance is monitored with what we call treaty monitoring bodies or treaty bodies. Now, what one finds and what's relevant in the present context is that these treaty bodies can call on states to ensure that a community's sort of a specific religious or customary law of a community is abolished or reformed in order to comply with that state's legal obligations. And I think what's significant in the present context is that it demonstrates how international legal obligations can act as a constraint on the permissible contours of autonomy arrangements. Additionally, it demonstrates the kind of challenges that a state can face in terms of respecting a community's autonomy while simultaneously being required to ensure that the exercise of this autonomy remains compliant or consistent with the state's own international obligations. It also clearly has obligations for the community itself because it reveals one potential cost of autonomy in terms of the reform agenda that the community may be compelled to embrace. Now, what I'd like to do in this very brief presentation is to make a few general observations about legal pluralism and some of its implications for autonomy arrangements, the impact of this nexus with international human rights in terms of the operation of these autonomy arrangements and in terms of the community-state relations and intra-community relations. And to avoid an overly abstract discussion, I draw on some insights from Southeast Asian states in terms of the opportunities, but also the risks and challenges that these types of what I call plurilegal autonomy arrangements can actually pose. So just to deal with a few preliminary issues, in terms of what we mean by legal pluralism, it just basically means the coexistence of more than one legal or law-like system within the same geographical and temporal state. Now, there's a huge amount of discussion about what constitutes a legal or law-like system, but I think for present purposes, it's sufficient to note that religious and customary law is accepted as law by the communities concerned and generally by states. The other thing is about what kind of forms this pluralism can take. It can take many forms. It can be legal, de jure pluralism, or it can be de facto. But when you have a state granting autonomy to a community to regulate certain matters in line with its own religious or customary laws, then invariably you're talking about de jure legal pluralism. And that has practical implications because where you're talking about de jure legal pluralism, It means the responsibility of the state is directly engaged. It will be responsible for any human rights harm caused by the operation of these laws. It will mean that the state will have to ensure that the autonomy arrangements remain consistent with its international human rights obligations, not just when the autonomy arrangements are put in place, but over time to maintain their operation is consistent with its obligations. What this means in effect is that the state will need to remain actively engaged with the community, even in relation to what that community might regard as exclusively internal matters for it to regulate. In terms of the scope of legal pluralism, it usually means that it allows a community to regulate its own internal affairs and sort of often in personal status matters such as marriage or divorce. I think we have to be careful here that quite often we can see these personal status matters as relating purely to the private sphere and therefore not something of inordinate concern in the bigger scheme of things in terms of the organisation of the state. I think we have to be careful because there can be wider societal implications. If we look at Myanmar and the race and nationality laws there, we can see how personal status matters, control over issues like marriage and divorce, was used effectively to keep a community intact from perceived competition from other religious communities. Also, when we look at the scope of legal pluralism, we can see that even whether we're talking about them regulating personal status matters or certain criminal sanctions, there is the potential to generate human rights harm, notably when you're talking about the right to non-discrimination on grounds of gender, sexuality, religious identity, etc. And because the state will be responsible for human rights harm, and we know that whatever autonomy arrangements are adopted by a state, it will be responsible for the human rights harm that's generated by those arrangements. But the argument that I'm making here is that this will be heightened where autonomy entails legal pluralism, given the distinct human rights issues typically raised by some religious and customary laws. In addition to this, we're all aware that autonomy arrangements invariably raise questions about defining the parameters of the group and identifying its legitimate representatives. But legal pluralism adds an additional layer. The state can find itself being called to determine who within the community can provide an authoritative interpretation of a community's laws. But casting the state in this role can have unintended consequences, not only in terms of the nature and level of its engagement with the community, but also the risk that in choosing who provides the authoritative interpretation of these laws, it can lead to the suppression of minority or dissenting views within that community. And finally, when we're looking at the recognition of laws, a community's laws, it also entails quite often recognition of the community's justice system or religious and customary courts. And this in itself can raise additional issues. A state cannot grant autonomy to a community to establish its own justice system and then disclaim any role in the operation of what, following official recognition, effectively is now part of the state justice system. It would be contrary to the state's duty to ensure the equal and non-discriminatory application of the law. It means that the state will have to guarantee that any variations in the application of the law can be objectively justified, not just at the point of granting autonomy, but also over time. And this means that there has to be ongoing engagement between the state and the community, revealing one potential paradox of these autonomy arrangements. Now, turning from legal pluralism specifically to international human rights law, one encounters several trends in the practice of UN treaty bodies that is relevant to the operation of what we could refer to as these plurilegal or legally pluralist autonomy arrangements. One finds that they regard some of the religious laws or customary laws, and by no means all laws, but just some of them, as problematic or incompatible with a state's human rights obligations, such as, for example, child marriage laws. And they will call on the states to abolish these laws. Now, some states have already taken action to do so, but we have to be cognizant of the fact that it can affect relations between the state and the communities, especially where the community is resolutely opposed to abolishing the laws. So it can put pressure on them. A second point is that where religious and customary courts exist, the treaty bodies ask states to regulate them to ensure that they comply with human rights norms, and most importantly, that a choice of court exists. Now, this is very important because it ensures that people belonging to these communities have a choice, that they're not compelled to submit to the jurisdiction of the religious and customary courts. In this way, it can safeguard individual autonomy. It also minimises the risk of generating centrifugal tendencies whereby individuals feel compelled to look to their own community for protection of their rights and interests rather than to the state. It also makes sure that there are exit routes available should they wish to leave the community. Now, states sometimes adopt a resolutely non-interventionist policy in these areas, but what one finds is that that does not shield them from international scrutiny, and they will be called upon to work with the community to reform any problematic personal status laws. It shows that it can provide an impetus for this legal pluralist dimension, provides an impetus for greater engagement between the state and the community, and in ways that might not be readily apparent from the original grant of autonomy. On other occasions, one finds that the treaty bodies ask the state to help reform any problematic religious or customary laws. The emphasis is very much on constructive engagement, but the very need for states to have frank and constructive discussions about law reform carries with it certain risks for relations between the state and the community that cannot be underestimated. A fully inclusive reform process is always required, and this is quite interesting because it means that it's a way of testing whether claims advanced in the name of religion or culture are actually relevant today, that it minimises the risk of restricting the rights of members of the community to protect outdated aspects of that community's identity. And it also ensures that one of the enduring concerns raised by minority protection is addressed, namely that the rights and interests of the group will take precedence over individual members. Now, this is not to go down the route of a completely individualistic approach to rights. All it's saying is that rather than the group and the group rights being automatically given priority, that essentially you allow for some reconciliation between the rights of the group and the rights of individual members. As few human rights are absolute, there is that built-in flexibility to accommodate and reconcile competing rights and interests. So it follows that whenever we're talking about autonomy arrangements that give rise to legal pluralism, one has to factor in this explicit human rights dimension, as a failure to do so can result in these arrangements having unintended consequences. At the very least, it will avoid generating expectations about the degree of autonomy that legally the state might not be able to grant. Now, admittedly, much will depend on whether the state is willing to comply with its international human rights obligations, and that's not exactly a given, but it's something we need to bear in mind. For members of the community, though, it does have implications. It can ensure respect for their autonomy in relation to community membership. It can afford protection to the multifaceted elements of their identity, so that there is not just one overriding dimension that's protected. And it can protect those whose daily lives are impacted by religious and customary laws. And one cannot underestimate the amount of people who are impacted on a daily basis, either de jure or de facto, by the operation of these laws. And this is not to say that we have a completely negative approach to these laws. These laws quite often reflect the will, the people's own wishes, but is that they can be problematic in certain areas. Essentially, it has also implications for the community. Sometimes human rights can, interestingly enough, require the adoption of autonomy arrangements. We see this very much with Indigenous peoples, but it can also establish the permissible boundaries. And for the state, what we can see is that it can help to ensure that the rights not only of the individuals, but the community are protected, and in this way go some way to addressing kind of marginalisation and alienation. But at the same time, one cannot ignore the potential for tension and conflict where the state seeks to co-opt community leaders in reforming religious or customary laws, and those leaders oppose such reform processes. So very briefly, I know I've got maybe 3 or 4 minutes left. I'd like to just draw very briefly on some of the research that I've been doing in ASEAN states, Southeast Asia, where some of these issues have cropped up. And there's a couple of trends there. One sees that here, and we're focusing very much autonomy arrangements that recognise religious law rather than more customary law. We see it's very much confined to, or it applies in most instances to personal status matters. We also see the reaction within the UN human rights bodies, identifying the human rights harm raised by some of these laws and how they operate. It provides tangible evidence of the human rights impacts of some aspects of these autonomy arrangements. They also demonstrate the wider societal impact that can flow from the autonomy to regulate personal status matters. And I previously mentioned the Myanmar's race and religion laws, and that they illustrate some of the wider implications in terms of preserving a community from competition from other religious communities. The second trend in those in Southeast Asia tends to be that there's no choice of forum, as religious courts have exclusive jurisdiction over certain specified matters. This clearly has implications for individual members of those communities. For example, in Malaysia, the members of the religious community have to submit to the jurisdiction of the religious courts, even when they're seeking permission to renounce their faith and leave that community. So clearly, significant implications there in terms of their everyday lives. It can also serve to reinforce the community's control over these individuals. So then what then very briefly are the benefits, if any, of these autonomy arrangements? One sees that it can lead to much greater scrutiny of the human rights implications and the issuing of recommendations on how any harmful human rights implications can be mitigated. So far, these recommendations have had a mixed response from ASEAN states. They've accepted some recommendations, such as on laws concerning child marriage to raise the age of marriage. We see this in Singapore. Human rights awareness. We see this in Malaysia, capacity training, capacity building. But we also see that there are some challenges, especially in Southeast Asia, because trying to reconcile some of these laws with global human rights standards, one finds that it assumes a certain plurality of views on matters of doctrine. But what we see in several states in Southeast Asia is that there are restrictions on intra-religious pluralism. So in Brunei, Myanmar, Malaysia, and Indonesia, non-dominant sects within the Muslim community, for example, can be labelled deviant and have their right to manifest their religion restricted. And this is further reinforced by apostasy laws, blasphemy laws, defamation of religion laws. So it can really kind of impede the kind of debate that is needed to actually make that necessary reconciliation. You can also see that's very popular, sometimes these religious laws, notwithstanding the human rights impact. We see this in Brunei and in Singapore. But as Singapore has stated on several occasions, it will not advocate for reform of religious law, where to do so would risk societal disruption of societal harmony. But final challenge that one kind of comes across, and we see this in Indonesia, is that if you're trying to maintain that kind of compliance with international human rights obligations, it requires ongoing and effective oversight about the operation of these autonomy systems, that they're not only compliant at the time that the system is set up, but also over time. And what we see in Indonesia is that it can be very difficult where you've got that decentralization and autonomy arrangements. It can require a very high level of commitment in resources as well as political will to ensure the effective system oversight of any system that involves legal pluralism in its autonomy arrangements. So just to conclude, in summary, I think the key point that I found in the research and that I tried to bring out in the book chapter is that where autonomy arrangements entail legal pluralism, this needs to be made explicit and factored into the design and operation of these arrangements so as to maximise the opportunities associated with these arrangements and minimise the risks and challenges, not least of unintended and unforeseen consequences. So, thank you.
Thank you.
I have two questions for you. One is in terms of definitions. I have the feeling that in your view, what you call legal pluralism is the same than we call non-territorial autonomy, only applied in different areas. So legal pluralism is something for religious aspects, and non-territorial arrangements is something for the rest, the other cultural aspects. In that case, I would like you to be a little bit more, specific on the definition, or possibly these cultural, traditional elements in indigenous areas. And the second question is about the very important point that you have made about the international organizations and international minority rights in general. It is generally a problem in the monitoring, in the work of the monitoring bodies to deal with autonomy issues overall, including territorial autonomy that is normally more developed, but also it is very, very difficult because of lack of provisions in the treaties themselves, and also in the respect that the international community claims to have for the territorial organization of countries. So when you look at the monitoring of the advisory committee, for example, the provisions under Articles 15 and 16 when it comes to autonomy are very, very little relevant. And I wonder whether this is even more an issue for non-territorial arrangements. So do you think that there is some room for the international treaty bodies to help the development of functioning non-territorial or legal pluralist arrangements by being a little bit more proactive in promoting these instruments, and if there is some room that you can find in international treaties to promote that? Thank you.
Thank you very much. I think those were two quite in-depth questions, so I'll turn over to you, Helen, immediately.
Yeah, and thank you very much for the questions. In terms of the first one, the definition of legal pluralism, it's a really great question because once you start going into the area of non-state law, there is that real challenge of how do you distinguish between a legal system and a normative system. You collapse it, yeah? So on the outer edges, there can be that kind of difficulty. And in fact, for some legal pluralists, they've abandoned all discussion of legal pluralism. They just talk about normative pluralism because of the challenges of making that distinction between law and law-like systems with other normative systems. But I think, so what I'm doing here is adopting a very pragmatic international lawyer's approach to legal pluralism and what is law, in the sense that I'll treat anything as law if the principal addressees of the norms and third-party decision makers regard it as law, as opposed to just a non-legal normative system. And what one tends to find in the particular area that I've been looking at is that both the states and the communities concerned describe these rules not as kind of non-legal normative rules, but they describe them as law. So I would allow that kind of autonomy and self-determination of those involved to actually determine the classification. But I think with that first question, there's also a sub-question, which is this legal pluralism? How does it engage with non-territorial autonomy? And is there some allocation of functions, if I understand it right, that non-territorial autonomy will deal with certain areas? I think it cross-cuts non-territorial autonomy and territorial autonomy arrangements. Essentially, non-territorial autonomy, like all autonomy arrangements, it will come down to what is the subject matter of the autonomy. If the subject matter of the autonomy is regulation, as opposed to having the freedom to engage in certain cultural practices or religious practices, I think it really depends on what we're talking about in a specific instance and whether or not the regulation is determined by what is regarded by those concerned as law. So I think I wouldn't see legal pluralism occupying a space outside it. Actually, the whole point is that legal pluralism can be a feature both of the non-territorial and territorial autonomy arrangements. I don't know, does that quite answer the first question? On the second question, yes, I totally accept that international organizations often have to grapple with difficult issues in this particular area. What is their role? They are very circumspect when it comes to, say, for example, if we take the internal organization of the state, they will not really, as a general rule, dictate or prescribe what the internal organization of the state is or should be. But what they will say is that whatever system you adopt, and this is coming through very much when we're talking about alternative justice systems like religious courts and customary courts, they will say to them that, yes, you can have that system, but it must comply with the fundamental tenets and principles of international human rights law. And given that, there's certain conceptual coherence there. It's allowing that discretion, but also sort of saying to the state, you've signed up for this. And also we have to remember that behind a lot of these autonomy arrangements is the underlying rationale can often be to address the legitimate grievances and alienation of the groups concerned. There's often a rights-based justification for the grant of autonomy, so it's conceptually coherent to actually require the operation of these resulting autonomy arrangements to be consistent with these standards. And I would sort of say as well, when I talk about global human rights standards, we're not talking about something that requires standardization. There's huge amount of scope there for flexibility, provided it doesn't pass certain red lines.
Thank you. Again, Helen, I am looking to see if the other, I see, did you have a reply, Francesco? No.
I think Piet.
I see. Okay, we have one in the room here. Okay. Quickly, Pete, quick, short question, please.
Oh, okay. Short as possible. Thank you for your talk. And I was, so you talked about this conflict between human rights, individual rights, and kind of group rights. When it comes to marital law, when it comes to a lot of religious laws, I was wondering whether you apply the same kind of skepsis on group rights when it comes to language law.
Yeah. Very briefly, what I would sort of say is I wouldn't see it necessarily as, and I think this is unfortunate, it's often portrayed as a zero-sum relationship. It's either all good or all bad. That it's kind of somehow there is an inherent conflict. There is tension, I think, between these individual and group rights sometimes, but they're not necessarily irreconcilable. And that's not being idealistic. It's to say, rather than seeing it as a zero-sum exercise, calibrate and see where exactly the tension points are, and therefore how you can reconcile it. And I would say that would apply not simply in the area of sort of in relation to religious communities or when we talk about customary laws in relation to ethnic groups. It also applies to language rights. It's an area that I'm very, very interested in, would be language rights. And what we can see is that there is a lot of accommodation there in terms of language rights to accommodate competing interests between the community concerned, individual members of the community, and also wider societal interests, especially on the kind of financial dimension of meeting the needs of linguistic minorities.
Thank you. Did you have a question here in the room? No. Okay, I think we will say thank you then, Helen, because we are running behind schedule now, unfortunately. Thank you. And